Is it too late to apply for VAWA if your abusive spouse divorced you, died, or got deported? Not necessarily, but the clock is ticking. In this video, I'm breaking down the 2-year filing rule, what kind of abuse counts, and exactly how to build a winning VAWA case in 2025. If you're Googling, can I still get the green card after divorce? Or is it too late to file for VAWA in 2025? This video is for you. I'm U.S. immigration attorney Sharifa Tharpe. I help immigrants to get legal status in the United States while being here. So let's get into it. What is VAWA? And why is it a powerful tool in 2025? The Violence Against Women Act, better known as VAWA, is a U.S. immigration law that lets people who were mistreated or abused by a U.S. citizen apply for their own green card, their own work permit, their own independence without that person's permission, their signature, or their involvement. This type of mistreatment includes emotional, verbal, control or threats, violence, financial manipulation. So it includes all sorts of mistreatments, even if they do threaten you with your immigration status. And no, it's not just for women, it's for men, LGBTQ individuals, and stepchildren of abusive green card holders and U.S. citizens. So it does provide a lot of relief for varying situations. And now, VAWA is more important than ever. And yes, it is still available. So let's break this down. If your abusive spouse or the spouse that mistreated you divorced you, can you still apply for VAWA? The answer is yes, but you must file within 2 years of the final divorce date. If your spouse passed away, you also have 2 years from the date of their death. If your abuser or the person mistreated you was deported or lost their green card, you still may qualify as long as you file within the 2 years of their removal or loss of status. And let's clear this up. It doesn't matter who filed the divorce, you or them. What matters is the timing and whether you have the evidence of the mistreatment or the abuse. And we'll definitely get into what kind of evidence you can show. It will surprise you. So what counts as mistreatment or abuse? A lot of people think you have to have a police report, you have to have pictures of abuse. And if you don't qualify. But that's not true. Under VAWA, abuse can include emotional abuse, insults, threats, isolation, gaslighting, financial abuse, taking your money, making you beg for basics, immigration control, threatening to call ICE, refusing to help with your status, and things like sexual coercion, forcing you into intimacy, verbal abuse, constant yelling, threats, name calling. If any of this sounds familiar, you may already qualify, but you have to show the abuse clearly and consistently in your VAWA declaration. That's your statement, and that can be enough to get you this relief. So what evidence is needed to win a case? And this is going to surprise you. One of the most Googled questions I get is, do I need a police report to win VAWA? The answer is no, you don't. You don't need a medical report either. You can submit your personal written statement. That can be enough, but if you have other types of evidence like text messages, photos, screenshots, social media messages, photos of damage to property, letters from other people who witnessed this, proof of counseling, evidence of your relationship is going to be very important. VAWA is about telling your truth. USCIS officers are trained to understand that abuse isn't always visible. They can consider the full picture, and they're going to look at your statement and accept it as evidence as long as it is credible. That means believable. Should you wait to file? No. If you're still married and living with your abusive spouse, or you just recently separated, don't wait. In many cases, filing before divorce can actually make your case stronger. If you're filing after a recent breakup or separation, your memories are fresh, your evidence is easier to collect, and you're within the deadline to file. Remember, if you wait and the divorce becomes final, the 2-year deadline starts counting down. Let's do a lightning round of frequently asked questions. Can men apply for VAWA? Yes. Do I need my spouse's signature? No. Can I file VAWA if I overstayed my visa? Yes. What if I have a removal order? You may still qualify. You definitely need to get in touch with us to talk more about your situation. Can I include my children? Yes, if they're under 21 and unmarried. Can I work while my VAWA case is pending? Yes, once your work permit is approved. Can I travel? Only after getting the advance parole, and right now travel without it is definitely a no-no. Even travel with it can be risky. And if you still have questions, go ahead and drop those in the comments so we can go ahead and respond to you. So let me be clear. You could lose your chance at getting a green card forever if you miss your VAWA deadline. Whether you're divorced, widowed, or your spouse was deported, you only have 2 years. So don't wait for the perfect moment. Now is the perfect moment. Start your VAWA petition today. I'm U.S. Immigration Attorney Sharifa Tharpe. Me and my teams help immigrants file successful VAWA applications across the U.S., no matter where you are. I also share important information like this to help empower immigrants through their immigration journey. So make sure you like, subscribe, follow, do what you can so others can see this information and that you can also be up to date on the information I provide on a regular basis. In the meantime, take care.